Yes.
All right. That's right.
Not in person. Just having some technical difficulties. We can start.
Okay.
Or we could give Nancy another second. But I'd like to do a sound test for all the people who are online. I'd like to get a sound test for everyone who's online. Can we ask in the following order? Patrick, can you say hello, please?
Hello, yep.
Thank you, Dr. Busini. Dr. Kerrigan?
Here.
Dr. Drake, can you speak up so we can see if we can hear you?
Here.
And Mr. Parsons?
Here.
So we're gonna do this all over again.
And everybody remember to speak into the microphones, please, like close, please.
I don't think he doesn't need to be close. All right, you ready? All right, we're gonna call the meeting to order at 9:01 a.m. on 7/26/24. First item agenda is the roll call. Dr. Busini,
Here.
Dr. Coble. Here. Mr. Daniel. Here. Dr. Downing. Not here yet. Dr. Drake.
Here.
Dr. Kerrigan.
Here.
Mr. Parsons.
Here.
Ms. Zeman.
Here.
All right, the meeting's called to order. I don't think we need a motion yet because we know Dr. Downing's trying to get in. All right.
Here, present.
Oh, she's here now. Okay, everybody's here. All right, so the second item on the agenda is to review and adopt the minutes from the April 26, 2024 quarterly meeting. I hope everyone's looked at them. Is there a motion to approve the minutes?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Third item is the office administrative update.
So in your meeting materials, we have an updated fourth quarter budget status report. And we're on track to expend all of the GR and GRD that we have in our budget through the end of this fiscal year. Right now, we are awaiting instructions from the LBB for our next LAR cycle, so that's coming up. And we don't really have any other updates with respect to the budget. I'm happy to answer any questions regarding it.
Are there any questions by anybody?
And we'll have a new proposed budget for next year at the next meeting. With respect to the launch of the database functions, as you know, OCA has been building the database to publicly display the information that the commission has and has gathered over a number of years. They've finished launching all 6 sections of the database, and now the task is to populate all of those sections of the database with as much information as we can get, and that will take a fair amount of time because the laboratories will need to migrate their data from wherever they're currently storing it over into our database. And we need to go through and populate all of the disclosures with the information that is not subject to redaction or to being withheld for any legal purpose. So we're excited about that. It has been launched. And over time, it will grow in terms of the information that it has and that it is making available to the public. So do we have any questions about that, Mr. Daniel?
No, ma'am. Thank you.
And I think I did want to recognize that the TAFQAM, which is the Texas Association of Forensic Quality Managers in particular, they've been really engaged in that process and have been piloting each section, so we are grateful to their participation because we couldn't have done it without them for certain. I don't have anything else under the administrative update. Lee, did you have anything?
I think you covered it all.
I have to say that I recognize the intent of the database function, but I don't think that it's going to be as smooth as everyone thinks. And I think it actually will create more work because the attorneys will get what they can get and then send a subpoena and you'll be back doing the same thing to give them the same amount of money, the same amount of information or more.
So I think Dr. Farmer, that's probably a reference to the lab portal, the record portal, the discovery portal. And so I would suggest that all those comments can be directed right over there to Texas DPS since they are the ones putting it together. I think they will give us a little bit of an update later on in the agenda on that. And Mr. Daniel serves on that working group, so he may have some thoughts as well.
Especially if you can get some control of the attorneys on having them duplicate all the requests.
That's not possible, Dr. Bernard.
Yeah, that's kind of the point.
You know that.
All right, so if we have nothing else, let's move to item number 4, Mr. Daniel.
Yes, sir, this is disclosures and complaints. We have 10 new disclosures that have come in since our last meeting. We have one complaint pending from our April 26th meeting, and then a couple other complaints have come in as of July 5th. Our first item is 24.11. It comes out of the Jefferson County Regional Labs seized drug section. They had 2 items of evidence submitted by the Beaumont PD. They were inadvertently returned to the Port Arthur PD. The seals were intact. There was no indication of tampering of any kind. They sought to figure out how this happened. They determined it was just before a holiday. They had one lab personnel working that day who was charged with intake and returning evidence, and some confusion evidently occurred. They have since updated their outbound evidence transfer documentation. They have updated their evidence handling procedures. And now I have a recommendation to divide the intake function from the evidence return between 2 separate folks, which is good. And they added a second reader to double check the receipt. And they did notify the appropriate folks, being Beaumont and also the Jefferson County DA's office. Staff had reviewed this carefully, provided extensive information, made a recommendation of what's been done is done, and no further actions needed. I concur with that, and I'm prepared to make that in the form of a motion. Any questions or comments? If not, I will make that in the form of a motion to take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our second item, which is 2412. It comes out of the City of Austin Forensic Science Department. It's an evidence handling issue. Back in May, the department had reported an incident in the lab where evidence control specialists were performing an inspection in the warehouse and found several cases with some soil and mold and water stained. 2 of the cases appeared to have some pressurized cans of liquid that may have leaked. One case did not have the external damage, and the internal contents looked sort of strange. They set about to review how it happened. They realized that the cases were somewhat dated. Of the 12 packages, they found that 10 of those were from the early 2000s. One was back in 97, one was from 2013. They suspect the damage occurred sometime before they had done a transfer of evidence to a new facility. They did undertake to photograph all the packages and all the evidence. They provided images to us in our meeting materials. As far as mitigations, they've updated the physical evidence handbook handling procedure with regard to pressurized liquids, and they are going to increase the frequency of visual inspections. It appears to me to be just something that happened. Staff, again, has reviewed this extensively and provided us an enormous amount of supporting documentation, and reached a conclusion that maybe no further actions necessary. The lab has agreed to report any future issues that arise out of this. So if there are not any questions or comments or concerns, I'm prepared to make that in the form of a motion. With no comments, I will make it in the form of a motion to take no further action on item 24.12.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our next item, which is 24.13, comes out of signature science, the forensic biology section. They were discovered a case after some internal review that the analyst or technical reviewer had determined a wide highest posterior density interval during interpretation, reporting, and technical review. The result was an unintuitive exclusionary statistic. They set about determining how this happened. They realized that in 2021, it affected 3 reports, an original report and 2 supplements. For a case, the lab utilized StarMix software for its interpretation and statistics. In March of this year, a CODIS analyst notified the technical leader of Signature Science what they had found during a CODIS entry of the unintuitive exclusionary likelihood ratio for one question sample in the case when compared to an individual suspect. They concluded, the lab concluded, that it had failed to note a higher posterior density interval during interpretation, reporting, and technical review. As far as root cause, the lab determined when it first implemented the StarMix back in sometime in 2018, the scope of their initial external and internal training did not include the issue of higher posterior density intervals. The historical review of meeting notes and internal emails indicated they received some preliminary guidance on that in 2019, but did not include that where it made any difference until 2022. They have since updated their version of the StarMix SOP to include guidance on HPT intervals. In response, they have amended reports for the cases at issue. They also performed a retroactive review of all StarMix cases issued by the lab. They expect that to be completed sometime along about September. They also modified their document review checklist to include an assessment for the need of retroactive review casework, and they plan to monitor the corrective action, report any further issues. We leaned on Commissioner Zemek, and she had asked the lab to explain how the SOP addressed the review and what criteria it used to identify affected cases. I believe she received a satisfactory response. Which occurred. The corrective action has been extensive. Staff had brought forth a recommendation to take no further action. I'm prepared to make that form of motion unless there are any questions or comments.
I do have one comment,
Yes,
Mr. Daniel, which is that we had discussed, because this keeps popping up in different labs, this issue of the wide HPD interval and how to address it. So we are tentatively planning, folks can mark their calendars, but there will be email sent out with respect to this soon to do a training on this issue virtually August 26th. So that is incoming for all of my DNA folks in the audience. Thank you.
Any other thoughts or comments or questions? If not, I will make that form of motion to take no further action.
All right, is there a second?
I second.
All those in favor say aye.
Aye. Aye.
Opposed? Motion carries.
Which will bring us to our fourth item, which is 24.14. It comes out of the Corpus Christi PD crime scene unit. They had reported an employee may have falsified some information on a crime scene investigation. Their crime scene supervisor became aware of a situation involving an unsealed evidence envelope that were blood swabs from a patrol unit that were found inside a crime scene vehicle. They spoke with the employee. He knew about the lost items, but he did not disclose that information to management or upper staff. He also went back to retrieve the second sample the next day to make it appear as if the original sample had somehow been inadvertently left in the vehicle. He ended up recording incorrect information for the second sample collected. He demonstrated the employee misrepresented the second sample as well. The lab placed the employee on administrative leave in connection with their review. They did undertake to notify the Oasis County DA's office. They also notified the commission, also ANAB. They did complete a internal affairs report. They had a hearing, the employee was terminated, appealed that, it was actually sustained. They essentially reviewed all the cases that the employee had been involved in. It only involved 6, thank goodness. And they found about 3 discrepancies in each instance. It consisted of bedding and clothing that had been packaged together when they should not have been. I think it's been corrected. Staff had brought forth a recommendation to us that we take no further action in light of the analysis and also the corrective actions taken by the lab, and also including the internal affairs investigation, the fact that he's no longer employed with that police department. And if there are not any questions or comments or concerns, I'm prepared to make that in the form of a motion. We take no further action.
No questions or comments? Motion's been made. Is there a second?
I'll second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to the 5th matter, which is 2415 from Sorensen, Forensic Biology DNA Unit. They had an incident in the lab where they discovered they did not validate a bone processing protocol prior to its use in casework. The lab had given several individuals approval to use that protocol. They did notify clients that had been impacted by this. They offered retesting if necessary. They also reviewed authorizations for all employees back from 22 forward as to ensure all laboratory methods had proper validation and performance check. The lab is working on a new validation plan that they use for final effectiveness check and its corrective actions. Staff had reviewed this extensively and had brought forth a recommendation that the commission would take no further action. If there are any questions or comments or concerns, I'm prepared to make that in the form of a motion. I will move we take no further action.
Is there a second? Second. All those in favor say aye.
Aye.
Opposed? Motion carries.
Our 6th item is item 24.117 from DPS Austin Toxicology Unit. They determined that an analyst had failed to dilute a submitted blood specimen prior to sampling for both alcohol and drug analysis as required by lab policy. The dilutions required where there's less than 1 milliliter of specimen available, and submitting also requires both blood alcohol and drug analysis. In this specific kit, the one tube was empty, the other contained less than 1 milliliter, so it should have been diluted according to policy. The analyst failed to dilute that before sampling as required by the policy. Due to the low volume, when the analyst attempted to utilize normal sampling volume again, for the second analysis, there was not enough remaining to generate a result. The reporting ethanol results require averaging of the 2 results, so they're not able to generate a second analysis. It affected the impact adjudication of the case due to inability for the lab to complete the tox analysis. They released that report to the customer and indicated the same. We're hoping that was provided to the defendant. The lab reported it appropriately to the Hayes County Sheriff's Office. They notified the prosecuting attorney's office also. They sent a report to the customer indicating the inability to provide results. And they provide a training refresher to the analyst with regard to dilution, and had the analyst complete some exercises. What's done was done, appears to be corrected. Staff have brought forth a recommendation to take no further action in light of all that had been undertaken, which I concur with. And if there are not any questions or comments, I'll make that in the form of a motion. I'll make a motion to take no further action.
Is there a second? Second. All those in favor say aye.
Aye.
Opposed? Motion carries.
Do you want me to take this on, sir?
Dr. Drake.
Good. I believe Dr. Bernard is going to recuse on the next item, which is item 24.23 from Southwest Institute of Forensic Science, tox section. A refrigerated evidence registration unit holds Dallas Police Department DWI blood evidence. And back in February, a circuit breaker had tripped. The lab noted had previously analyzed all the evidence, and the items were waiting pickup by the police department. They did relocate the evidence about 2 days later, so it's been 2 days, I guess, without refrigeration. They compiled a list of all affected cases. They notified DPD. They notified the Dallas District Attorney's Office. They've since developed a preventive action plan that includes a temperature monitoring system. And they're going to get purchase a new temperature monitoring system. And if the refrigerator becomes non-operational, the department will be notified immediately. Dr. Murray, I can't believe you allowed this to happen.
I have a lot of control over the electricals in that building.
He's recused. Recused.
He still needs to be held responsible for what he did. And so these things happen, and staff had made a recommendation, which I concur with. We take no further action despite what he did.
This is all on record.
Yeah. And I'll make a motion this time, we take no further action.
All right.
Dr. Gray.
All right. Is there a second?
Second.
Okay. All in favor, say aye.
Aye.
Any opposed? Okay. Ayes have, and the motion carries.
Which would bring us to the next item, which is item 24.24, the Plano PD Crime Lab Latent Print section. They were undertaking an audit of some kind of cases analyzed in the section. They found 2 specific quality events where analysts were removed from casework. One, the laboratory identified an erroneous exclusion on a latent print analyst proficiency test during review. And the second, the lab identified a second erroneous exclusion on another latent print analyst during a technical review. The lab attributed the second order to some issue in the orientation issue of latent print. In response to nonconformities and other corrective actions, the lab manager decided to perform a complete audit of its latent print cases. They reviewed about 40 cases, they did review 40 cases. They found that 17, there was no errors whatsoever. They found about 10 that had some administrative errors, which included worksheets, forms, failure to initial and sign by examiners. 13 of those did have some form of technical errors where they were not originally compared, and they were deemed to be of value in the audit. They also had additional latent prints of value that were not marked appropriately, resulting in misidentifications. They had some incorrect orientation of prints leading to failure to identify, and also incorrect reasons listed for some inconclusive result. They identified the errors in a higher than expected number of instances. They believe this is attributable to inadequate training, failure to follow standard operating procedures, failure to follow appropriate methodology, also lack of consensus on issues such as suitability of a print for comparison. Their corrective action has been extensive. They updated their standard operating procedure, including a latent print procedure document, as well as more detailed guidance on report writing. They also added a sufficiency and exclusion criteria. They evaluated and updated their current fingerprint training manual. They added additional requirements to attend external advanced latent print training for all examiners. They continue to include a third comparison in the technical review and have more than one more individual responsible for administrative technical review. They've also added technical review form with the digital case file, and they're auditing additional cases. They properly notified all affected agencies, including Plano PD and Collin County District Attorney's Office and this commission. Their corrective action has been extensive. Their review of it has been extensive. Staff have made a respectful recommendation to take no further action. I don't know what else could have been done, but any questions, comments, or concerns? If not, I'll make that in the form of a motion. We take no further action in item number 24.24.
Is there a second? Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
Our next item is item 24.25, coming out of the Berry County Criminal Investigation Laboratory Seized Drugs Unit. They report an incident in their section of the lab discovered after some post-submission process that forensic scientists had inadvertently switched two samples, and guess what, led to incorrect results on both. During the initial review of the drug identification analyst test results, the quality manager discovered that one of the test takers may have swapped to the proficiency test samples. The supervisor found a relative ratio of delta-9 THC in the forensic science samples run on the gas chromatograph were consistent with test samples run by other analysts. However, their data seemed to be flipped. And the laboratory revoked analysts' authorization to perform THC casework and technical reviews during the investigation. The forensic scientists also discarded the test samples from the proficiency test before the lab identified the nonconformity. The forensic scientists is one of the lab's highest volume producers or caseworkers. The majority of the reworked case samples were found to have slightly higher percentages of delta-9 than the values that the forensic scientists actually calculated. They set out to test a total of 57 items. They found that 42 had no lab number, 9 had the wrong number, 2 had the wrong date, 1 had an item where they failed to be opened or not repackaged properly, 2 items had a wrong number, and 1 had plant material that was not homogenized. So, by way of corrective action, the lab did notify all the district attorney's offices affected, but they also decided to add a disclaimer to their procedure used for THC testing, where they note that all analytical results generated by the procedures are representative of a percentage concentration of THC by weight present in sample at the time of analysis. They also plan to completely retrain the forensic scientists on THC casework and possibly reinstate their authorization to perform that work and technical reviews contingent upon completion of retraining. With regard to staff, they had done an extensive review of this investigation. They had brought forth a recommendation of no further action in light of what's been done. Any questions or comments? If not, I will make a motion to take no further action.
Is there a second?
Second.
Second's made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And then we have our section of missing evidence of self-disclosures. This one, 24.18, comes out of the DPS Laredo, the seized drug section. They had an incident in the seized drug section where the lab discovered during an audit that it could not locate one clear bag, which had about 200 grams of marijuana in it. When the analysts pulled the original evidence, it had 7 black wrapped bundles containing plant material and also a clear plastic bag containing plant material way back in 2023. The analysts took 7 of the representative samples from the 7 bundles and packaged them inside a brown box. The lab considered the rest of the bundles excess quantity to be reduced and destroyed in accordance with Texas law, and evidently that happened in October 2023 when the evidence technicians inadvertently destroyed the evidence. The lab, in response to this, has adjusted procedures. They notify the submitting officer of their attorney's office of the non-conforming event. They've updated the chain of custody to include accurately reflecting the status of the evidence as not being able to locate it. They're going to include new procedural requirements for destruction of evidence from the regional manual and its local manual. What happened, happened. Any questions or comments? Staff have made a recommendation to take no further action. I will make that in the form of a motion.
Is there a second?
Second.
All right, all those in favor say aye.
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 Opposed? Motion carries.
Which will take us into our complaints. The first is a holdover from our April meeting. It's item 24.01 from Ya Lee against the Harris County Institute of Forensic Science, their biology DNA section. The complaint was filed by the spouse of a capital murder suspect regarding complex DNA mixture in a pending capital case in Harris County. The case involved the murder of the defendant's employer, the employer's wife, and 2 children. The sample in question was a star mix DNA report, which had findings from the handle of the deceased woman's purse found at the crime scene. The lab determined a number of contributors to the mixture was 3 folks and reported likelihood ratios that include the defendant and members of the deceased family. The complaint asked the commission to review and determine whether the lab has established some correct thresholds for determining the number of contributors. Staff referred this matter to Dr. Coble and Ms. Zeman for review. They had reviewed the matter and I believe they received satisfactory responses. Staff recommend no further action based on the review of Commissioner Zeman and Coble. And due to challenges inherent in DNA mixture interpretation with related parties involved, the Commission hopefully will include this as a subject of part of its training for DNA in future programs. Dr. Cole, Ms. Zeman, any other further comment on that?
No further comments.
And in light of that, I will concur with the recommendation to take no further action and make that in the form of a motion.
Motion is made. Is there a second?
Second.
Second's made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And then we have 2 other items that were complaints received as of July 5th of this year. First is 2420. I'll be brief. It's a complaint filed by Roy Smith where he was requesting, quote, DNA results, end quote, related to a case where he entered a plea of guilty and been sentenced. He alleges that he requested results from the DA's office and requests have been refused, and also requested results related to the victim from the local hospital. Staff have made a recommendation. The Commission has no jurisdiction over post-conviction release of records, which we do not. It also made no allegation of actual professional negligence or professional misconduct. So in light of that, I would concur with staff's recommendation to dismiss and make that in the form of a motion at this time.
All right, motion's been made. Is there a second?
Second.
All right. Motion's been seconded. All those in favor say aye.
Aye.
Opposed? Motion carries.
I think that indicates how to put them to sleep. What do you think?
Oh, I can understand that.
Yeah. Which will take us to our last item is complaint 24.21. It came from Mr. McTier. He's requesting assistance of this commission to obtain DNA results in a matter out of Harris County. It alleges that some Chapter 64 DNA violation concerning testing. He's been unable to obtain results, even though the testing was performed. We have no jurisdiction over that. Staff have made a recommendation to dismissal because we have no authority to compel disclosure of DNA testing results. It also made no clear allegation of professional negligence or misconduct. And I'll make that form of motion that we dismiss this complaint 24.21.
All right, is there a second?
Second.
Second's made. All those in favor say aye.
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 All right, motion carries.
And I believe that concludes the complaints disclosures item. Thank you, sir.
Yes, sir. Thank you. All right, agenda item number 5 is the status of crime laboratory accreditation program.
This quarter, the commission received 6 reported accreditation-related events. 5 of those were surveillance document reviews and continuations of accreditation, and 1 was a scope extension combined with an assessment for that scope extension. Of the 6 laboratories that had accreditation activities this quarter, there were 0 nonconformities cited, so we just want to congratulate those laboratories on that success. Moving on to reported proficiency testing, non-consensus results, the commission received 17 reported non-consensus proficiency test results, and 3 of those were answers that were just outside the validated reporting limits of the lab. 3 were clerical or data entry mistakes by the test taker or the lab, and 5 were results that may impact proficiency or require further root cause analysis. 3 were test takers not yet authorized for a particular method that was being asked for on the test. And then 3 of those were forensic DNA interpretation. Staff is working on follow-up for 2 of these that are in our meeting materials, and we will follow up on those at our next meeting. Did you want to add anything to that, Robert? Does anyone have any questions on the accreditation agenda item?
All right. Next is discuss the updates from the Licensing Advisory Committee.
So on the first item here, right now we currently have 1,305 licensees. The next thing that we'll be doing in the area of licensure is renewing for the last time, the last cycle, where we have a heavy number of renewals in the fall of even numbered year, because we're still working on transitioning through that birth date transition. But this fall, October, November, and December, we have a couple hundred each of those months to renew licenses. At the same time, we're also going to be transitioning to a new licensing platform system that's made for applying for a license. So we're going to transition away from Top Class, which is the current provider that we use, which is essentially an LMS, not really an application for applying for a license or renewing one, to a new system called Alice. And so we'll be working with the developers on that. We think it probably won't happen before all these renewals come up for our application, but hopefully by January of next year, we'll start launching that new platform for folks.
And that, just to tag on to what Lee said, it's the same system that OCA uses for the Judicial Branch Certification Commission, which has certification and licensure authority over court reporters, process servers, interpreters, guardians, and so on. So we'll all be on the same unified system, which is something that the Administrative Director, Megan Lavoie, prioritized, which I think will be a better user experience for everyone than what they're currently doing.
On item B here, one of the key votes that the Licensing Advisory Committee took yesterday was that they voted to form a working group or a task group led by Ms. Michelle Paulson from Plano PD and in collaboration with Karina Haynes to develop guidance that's aimed at smaller agencies and labs for inter and intra-agency proficiency monitoring, creative ways to evaluate proficiency for crime scene in particular, and possibly extending to other disciplines depending on the models that the group comes up with for testing. So Michelle is going to be working on getting that group together for us in between now and our next meeting. On C here, this is a rulemaking that is an adoption from a proposal that you all recommended that we adopted at our last meeting. And what we're doing here is creating new license categories for latent processing technicians and the crime scene disciplines that we've discussed in the past 2 meetings. We also are elevating the education requirement for document examiners to a bachelor's degree. It was formerly a high school diploma. So staff is asking for, the Licensing Advisory Committee recommended that this committee adopt this rulemaking.
All right, is there a motion to adopt amendments to section 651.202 and 651.222, subject to non-substantive revisions from the Office of the Governor, Texas Register and Commission staff?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
All right, the next item D here, this rulemaking is an adoption from a proposal that you all recommended adopting at our last meeting. The Licensing Advisory Committee has recommended that this commission adopt it. This effectively ends the birth date expiration rule going forward so that we don't have those prorated licensing fees and prorated continuing forensic education requirements. And that's because we're no longer facing the dilemma of a majority of licensees expiring in the fall of even numbered years anymore. So we ask you all to take a vote on this.
All right, is there a motion to adopt amendments to 651.207 and 651.208, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register and Commission staff?
So moved.
Second?
I'll second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
All right, on E here, under the Licensing Advisory Committee agenda item, this is a statistics course that's up for review by this commission. Yesterday at our Licensing Advisory Committee meeting, the members recommended that you all approve this statistics course as equivalent for the 3-semester credit hour college level stats course that's required of licensees. We have Shelley Rossi here, who's worked closely with Lone Star College in developing the syllabus that you have before you. And yesterday we added 2 components to it and uploaded a new version of that so that it covers Bayesian principles and likelihood ratios as well. So we're asking you all for a vote to adopt the committee's recommendation that we approve this course.
All right, is there a motion to approve Lone Star College statistics course as an equivalent 3-semester credit hour college level statistics course in fulfillment of licensure requirements?
So moved.
Is there a second?
Second.
Second's made. All those in favor say aye.
Aye.
Opposed? Motion carries.
I wanted to just take a second to thank Shelley Rossi because she found a certified peace officer who's also a statistics professor and got that person to teach statistics to law enforcement, which is a pretty impressive feat. So thank you for all your work on this, Shelley.
It's the one and only in the state. Okay. F?
All right, I think the final item here, we also said goodbye to 3 committee members yesterday. It was our last meeting at the Licensing Advisory Committee. And one was our chair, Sandy Parent, so we thank her for her service. One was Ed Wallace, and that's because he resigned to move out of the country. And our prosecutor, Callie Bailey, also, we said goodbye to her as well. And so today we have a candidate matrix before us and resumes for candidates to fill these 3 seats, 2 of them being scientific seats and 1 being the prosecutor seat. We have a nomination from the Texas District and County Attorneys Association for Miss Jessica Frazier of Comal County to be appointed to the prosecutor seat. And then we have a list of quite a number of candidates that are highly qualified to fill 1 of 2 of the scientific seats.
I think the only thing I would add to what Lee's saying is that the candidate matrix that we got from TACLIT is really quite impressive and extensive. And to those who did apply, anyone would be fabulous. And Lee and I just, when we get all the CVs, we just sort of stare at each other and say, like, how do we even decide between all these great candidates? But I think what it came down to for us is that with Ed Wallace moving back to the UK, we needed a firearms person, and Dion Christoph from Plano PD has expressed an interest in serving on the LAC multiple terms, essentially since he's been with Plano PD, and he also serves in leadership roles on the SAFTI, which is the Southern Association of Firemen Tollmark Examiners, and the Texas II Education Committee. So for Texas II and SAFTI, those are really important organizations for us, making sure that we are receiving feedback from the communities that the commission, that our work may affect. And then with respect to Megan Lee Rommel, she is a very experienced, well-known DNA analyst, has served in many capacities, not officially with the commission, but has attended many trainings. We're very familiar with Megan. She's a very senior person, and I think she has a lot of expertise and experience, and will definitely speak up about the things that impact the DNA community. So I think That was our thought process, but there are many qualified folks in the matrix.
So, is there a motion to reappoint Angelica Cogliano, Jessica Frazier, Dion Christoph, and Megan Lee Rommel? Or is there an alternative recommendation that covers 2 attorneys, as well as firearms and DNA?
And I think you mean on the licensing advisory committee, and if that's the case, I will make that in the form of a motion.
Sorry, yeah. Is there a second?
I second.
All right. All those in favor say aye.
Aye.
Opposed? Motion carries. All right, item agenda number 7.
For agenda item number 7, we're adopting a rulemaking that simply changes the numbering of 651.402 to 651.401.
All right, is there a motion to adopt new rules, section 651.401, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
Yes, sir. I'll make that in the form of a motion.
Is there a second?
I'll second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Leads us to agenda item number 8.
Going to do a PowerPoint on this one, so just give me a second to set it up.
Dr. Bernard, I need to recuse on this one, just FYI.
Yes, I was gonna mention who need to recuse on this, but we need to go over the presentation first.
Okay. Okay. This agenda item is about a topic of great interest to the forensic DNA community, not only in Texas, but nationally and actually internationally as well. So we are going to go through the report, a summary of the report that is in your materials on complaint 23.67. And I'm just going to give Steve a second to turn this on so that the commissioners who are present have an easier time seeing the slide deck. Okay, hopefully everyone can see that. So this complaint involves DNA interpretation, specifically evaluations given activity level propositions. The case is State of Texas versus Caitlin Armstrong out of Travis County. The complaint was filed by Tiffany Roy, who's a DNA consultant, against Dr. Timothy Califoot. So I just wanted to remind everyone about the limitations of the reports that the commission publishes. So no finding by the commission constitutes a comment on the guilt or innocence of any individual, and these limitations apply to all of our reports. Our written reports are not admissible in a civil or criminal action, and the commission does not have authority to subpoena documents or compel testimony. And so what that means is that we really rely on people's willingness to provide us with information and respond to questions that we have. I don't know, is this not my clickers? So in terms of the criminal case background, in May of 2022, professional cyclist Mo Wilson was shot and killed at her friend Caitlin Cash's home while she was visiting Austin to compete in a gravel race. The state's theory, which prevailed at trial, was that she was murdered by Caitlin Armstrong. And the reason for this was that Ms. Armstrong was jealous of Wilson when she discovered that Wilson had spent some time earlier that same day with Armstrong's boyfriend, who was also a professional cyclist named Colin Strickland. So hours before Ms. Wilson was murdered, she went with Strickland to Deep Eddy, which is a popular public swimming pool here in Austin. They ate dinner together, and then Strickland drove Wilson back to Ms. Cash's home on his motorcycle. Mr. Strickland said that he'd never entered the house. When he dropped Wilson off, he dropped her off and left. Hours later, in response to a 911 call, police arrived and discovered that Ms. Wilson had been shot multiple times in Ms. Cash's home, and her racing bicycle was missing, and police found it discarded outside the home. So investigators collected DNA swabs from the bicycle seat, as well as the handlebars of the bicycle. Those swabs were sent to Texas DPS, to the CAP lab in Austin, and there was DNA analysis performed and a likelihood ratio generated after the samples were run through StarMix, which is a probabilistic genotyping software system that many people here are familiar with. So for the bicycle seat, the DNA results were best described or explained as a 3-person mixture was the determination made by the DNA analyst. And she reported that the evidence was 224 billion times more probable if Wilson, the victim, Armstrong, the suspect, and an unknown person were contributors than if Wilson and 2 unknown people were contributors. Mr. Strickland was excluded. And then with respect to the handlebars, the DNA results also were best explained, according to the analyst, as a 3-person mixture. The DNA evidence was 49,400 times more probable if Wilson, Armstrong, and an unknown person were contributors than if Wilson and 2 unknown people were contributors. Strickland was also excluded. So I wanted to start here with some threshold observations regarding DNA transfer, which is really, I would say, of all of the issues that come up with respect to activity, probably one of the areas that most questions are asked of analysts when they're on the stand. And so this actually comes straight from NIST, the National Institute of Standards and Technology, foundational review that they did on DNA mixture interpretation. And they point out that highly sensitive DNA methods increase the likelihood of detecting trace amounts of DNA. As the technology improves, it becomes more sensitive, and that means the likelihood of detecting trace amounts increases. DNA can be transferred from one surface or person to another, and this can potentially happen multiple times. When assessing the value of evidence that involves very small quantities of DNA, it may be especially important to consider this fact in the context of any case that you might be looking at. So, context of the DNA evidence is important. The DNA evidence alone has limitations about what it can tell the trier of fact. So specifically, DNA comparison statistical results, so in this case, those would be those likelihood ratios that I just described to you, that DPS reported. They do not provide information about how or when the DNA was transferred, certainly not alone, they don't provide that information. So what NIST cautions is that using the likelihood ratio from the DNA testing as a standalone number without context can be misleading, and they're issuing this observation with respect to DNA testing nationwide. This is not Texas specific, it's not this case specific, it's just a general principle. The fact that indirect transfer may occur doesn't negate the value of DNA evidence, however. The value of the evidence depends on the circumstances of the case. So understanding how the DNA evidence may have got there requires a separate evaluation. So in this case, Samantha Perkins from Texas DPS was first to testify about DNA evidence. She testified about those likelihood ratios that I described to you earlier, and she said that the results help answer the question of whose DNA contributed to the mixtures from the bicycle, but not how the DNA was deposited. She made clear that questions regarding activity, in other words, how the DNA may have gotten there, would require additional information, and there's a whole body of literature on transfer that was outside the scope of her expertise. And I add a little gold star here for Ms. Perkins, because this was a very difficult set of circumstances, a very high-profile case, and when you read her transcript, you can see that she is really endeavoring to stay within her lane of expertise while not appearing evasive or unwilling to respond to the question. So I think, Sam tried very hard to give testimony that would be helpful to the trier of fact and would stay within her expertise. Because I know, well, we'll get to this in a second, but this is challenging for analysts. It's probably the most challenging thing they're facing right now. But to be clear, just because Sam was giving the results from her DNA testing did not prevent the lawyers from asking her activity level questions. That happens all the time in court. So a common back and forth you might have with DNA analysts and lawyers is, is it possible that the DNA got there this way or the other? Is it possible? Any number of potential scenarios. And then the analyst may say, well, it's possible. And then the lawyer may say, well, it's probable. And then the answer is, well, what exactly are you talking about? And there's a lot of that depends. And then the poor analyst is trying desperately to prevent themselves from being trapped in a box by the adversarial system that is trying to get them to answer something that they may or may not have an answer to. And sometimes it's challenging for the analyst to both be helpful to the trier of fact and stop themselves from being led down a path that will get them in trouble in terms of saying things that exceed either their understanding of the literature on transfer, their experience, their understanding of what the data say and don't say, their knowledge of how to extrapolate information from literature back out to these considerations. There's a lot of treacherous territory for DNA analysts, and I just wanted to recognize that because this is difficult territory for DNA analysts. And I want to make sure that people understand that the commission knows that and that we are have a lot of empathy toward what the task is within this adversarial system. It's a hard thing for people to do and do well. So we want to point out when it is done well, and I think Sam Perkins' transcript is a good example of that. So I keep talking about activity level propositions, and I wanted to set out for you what is the framework in the literature about the hierarchy of propositions that applies to forensic science evidence in general, not just DNA testing. So what they're talking about in this framework is that there are certain propositions within an evaluative framework. At the very top of this hierarchy is the offense proposition, which is about whether the person who's being tried is guilty or innocent. That is not a scientific question. It is not for the scientist, generally speaking, to weigh in at that level of proposition way at the top, because that's typically going to be reserved for your fact finder, the jury, or the judge. Activity propositions are what we're talking about here, which is what activity caused the DNA to be transferred. And here you need a lot more information than what you need when you do DNA testing. Below that is source proposition, so the question that's being addressed there is, can the person of interest be associated with body fluid or cell type, blood, semen, saliva, or epithelial cells? And then at the subsource level is where that likelihood ratio that Ms. Perkins reported out, that's where that likelihood ratio lives here at the subsource proposition of, can the person of interest be associated with the genotype in the mixture without regard to information about the type of cells? So is the POI in the mixture, to simplify it? Now, I probably shouldn't simplify it. The real question is, what is the probability of the evidence given two competing propositions? Proposition A being the victim, the person of interest, and an unknown contributor. Proposition B being the victim and two unknown, unrelated contributors. So that's really the question that we're answering with subsource proposition. And then there's another level below, which we're not talking about in this report, so we will not get into that at the moment. And I am having an issue here. Did I lose everybody? Just a second, we're reconnecting. We're getting back on the Wi-Fi, just a second. Okay, so what we do. Make sure. Okay. So in this case, at the activity level of the hierarchy I just showed you, there were certain questions of interest to the fact finder. So the questions of particular interest in this case were with respect to that bicycle. So given that investigators found the victim's bicycle discarded outside the home, and the DNA testing results implicated the person of interest, Ms. Armstrong, the state's theory was that Armstrong picked up and discarded the bicycle at or around the time of the murder. So these were the first indication that how the DNA got on the bicycle was going to be of interest. The state's theory was that because the mixture indicated certain results that implicated Armstrong, that meant she must have had direct contact with that bicycle at some point. Now, to cast doubt on that version of events, the defense asked a series of questions about other ways that DNA could be transferred to an item. And so through a series of questions, they suggested that because Armstrong and Wilson had both ridden on the motorcycle and used the same helmet, though at different times, possibly, is it possible that Ms. Armstrong's DNA may have been transferred without her having touched the bicycle? So those were the questions of interest when it comes to how the DNA got there, and that's what was elicited at trial. So when Mr. Quartaro, who's the defense expert, was on the stand, he answered various hypothetical questions regarding different DNA transfer scenarios. And he attempted to differentiate his general knowledge on the subject of transfer from the expertise one would need to report a more formalized evaluation given activities. Ultimately, he opined that it was possible that Armstrong's DNA was transferred to the bike without her even touching it. And he also acknowledged that it was possible she did touch the bicycle. So what's wrong with this way of testifying? Well, under the law, there's nothing wrong with it, neither Texas law nor federal law. But under principles of evidence evaluation, which are throughout the international literature and are based on the laws of probability and reasoning within a Bayesian framework, the role of the expert is to consider the probability of the observations, the evidence given propositions, and not the probability of the propositions themselves. So what the analyst is meant to do is to give value to the results rather than providing a range of possibilities or explanations about the proposition. The theory behind that is all those it's possibles don't actually lead the fact finder anywhere, because truly anything is possible. So how helpful is that line of testimony? So under international guidance, that is not the way we should be answering these questions. Why do we care what the rest of the world says? That might be question number one, right? Well, we are transitioning to a probabilistic framework for DNA testing. That's what StarMix is. It generates a likelihood ratio that is all within and falls under the Bayesian framework that is articulated in all of the international guidance on this subject. So that transition is already underway for subsource results, which are reported as LRs, as I just said. The question before the commission in this case, and before the country right now, frankly, is whether the US will adopt another concept that's already utilized in some parts of Europe, in particular the Netherlands and Switzerland, Australia and the UK, which is to evaluate forensic observations in light of activity level propositions in a more formal way than getting up on the stand, being asked, is it possible, and responding to those questions. Now, the consensus on how these assessments should be made and reported, that has not been established in the US. It's not like they're doing this in other states and Texas is behind. None of this has been agreed upon within the US. But in this case, we see the first example in Texas of an expert attempting to do a formal or a formal activity level evaluation before trial, and to write that up and submit it to the state in support of the testimony. So the main point of the commission taking this complaint was to go through all the testimony and see how did it work out and what did we learn? What are we missing and what is left that needs to be done? So the prosecution, after Mr. Quartaro testified and the defense raised a series of questions attempting to challenge whether the state met its burden of guilt beyond a reasonable doubt, the state called Dr. Califoot in rebuttal. So the defense, because it was rebuttal testimony, the defense was not aware that Dr. Califoot was going to be testifying until very shortly before he arrived to the courthouse. 3 weeks before trial, the state had contacted him for assistance with their cross-examination of Mr. Quartaro, and they also discussed the possible scenarios around the bicycle, whether Armstrong had picked up the bike or whether the DNA got on the bike via the use of Strickland's motorcycle, which both the victim and Ms. Armstrong had ridden on at different points in time. Armstrong well before the day of the murder, and Ms. Wilson on the day of the murder. So as Dr. Califoot was driving to court to testify, the state also informed him of another explanation that had emerged during the questioning of the defense expert, which was whether the motorcycle helmet might have been a mechanism of transfer, or vector of transfer. So Dr. Califoot performed an assessment that he has asserted throughout this is aligned with international guidance on evaluations given activity level propositions. He opined that DNA evidence was more likely if it was a direct interaction with the bicycle by the defendant than if it was this series of indirect activities. He also testified that the evidence was much more likely if the first proposition, that the defendant grabbed the bicycle to do something with it, than this other chain of events, which is that the DNA got on the bicycle some other way, through the motorcycle or through the helmet. So very shortly after the testimony closed, we received a complaint. And the complaint alleged that Dr. Califoot's analysis and testimony departed from established best practices, including certain items, which we will get into later, but preparing a written report, researching relevant literature, assigning probabilities based on the literature, delineating the specific studies relied upon, and formulating balanced propositions. So where do we look for guidance on how to do an evaluation given activities? I'm showing you where it is. For those who are really interested in this, the main sources are EMSI, which is the European Network of Forensic Science Institutes. And they have two key documents that we looked to for guidance and that US authorities look to for guidance. One is their general guideline for evaluative reporting in forensic science, and the second is a best practice manual that they produced later on specifically for human forensic biology. In addition, the ISFG, which is the International Society for Forensic Genetics, they published some guidance back in 2019, and it lays out the principles for performing this work. And then finally, Duncan Taylor from Australia and Bas Kokshorn from the Netherlands published this textbook here. So for DNA analysts, this textbook is very instructive about what it takes to perform these types of evaluations. I will lend it to you, but I've become very fond of it, so I'm not letting go. So this is right now what's out there in the international domain. In the United States, there is the National Institute for Standards and Technology, which has the OSAC, which you're all familiar with. They are currently trying to work on these issues, though they don't have a document out for public comment yet, but it is in the works. So what does the guidance say about how to perform an evaluation given activity level propositions? There are essentially 7 steps that summarize the process for doing this. And I won't go into them in detail, but I can tell you that if you take a look at what this entails, it is quite complex, and it is clear that one needs more training than what you would typically get as a DNA analyst who performs STR typing or even interprets at a high level complex mixtures. This is an entirely different set of knowledge and education and skills that people need. So they lay it out beautifully in the book, and all they're really doing in the textbook is taking the literature and consolidating it into one place to try to help provide guidance for people. So after having reviewed what is out there in the international domain, we observed certain unresolved issues that are highlighted by this case, which make it challenging to take what's being done at the international level in certain countries and transport it here to the United States. So specifically, the questions that we're trying to get at is whether, how, and when we would integrate evaluations given activity level propositions in the United States, and while that is happening, assuming it even does happen, how are analysts meant to answer questions about transfer, persistence, prevalence, and recovery now? So the bottom line of this report, the big takeaway, is that what we don't want to do is replace one problem with another problem. So it is absolutely the case that answering a long string of is it possible hypotheticals can be misleading and unhelpful to the trier of fact. It's also true that refusing to answer questions about how the forensic evidence may have got on an item can be misleading and unhelpful. Declining to answer, giving a no answer. I'll give you an example. In GSR, this was an example brought to our attention throughout the course of this. If you have 3 GSR particles recovered from the backseat of a rental car and that's all you report out are the GSR particles, the trier of fact may not be aware that were you to study the back seats of rental cars of 50 cars in Houston, another 50 in Dallas, and another, and all over the state, you would see that a lot of them have GSR particles in the back of them, or particles that might comprise a test result that would exceed that minimal threshold. So if you don't, as an analyst, as a forensic scientist, let people know about that additional information because you're declining to opine on it, that can be problematic because the trier of fact may misinterpret the test results, not knowing that they actually have limited meaning and context. So that's all true, but what we observed during the course of this is that it's just as dangerous to proceed with activity level evaluations if you don't have the requisite education and training to perform them in a way that's transparent and robust. And there's a risk that what we're left with is personal intuition and speculation that is dressed up as an analysis, or in this case, dressed up as DNA analysis. That was the single biggest concern of all the lawyers we talked to in preparing this report, is the idea that an evaluation given activity may be misunderstood as having more objectivity than it actually does, that people would not appreciate the extent to which it is subjective. So we went through 10 unresolved issues for consideration in the report. One is that we don't really have a full appreciation for the differences in the legal system's approach to introducing forensic evidence at a threshold level. So they do things differently in the UK, Switzerland, the Netherlands, and Australia. Do they do it completely differently? Maybe not, but we don't actually even know that. We haven't done a survey to see all of that. We have some indication from the literature, but just by way of example, there are some countries where a judge will call the experts in and they will sit down and they will come up with sort of a consensus between them about what scientific issues are not in dispute, which ones are. They work it out. It's all very civilized around a table. We handle a lot of these things through the adversarial process. It's a different situation. The role of the expert is different in some of those countries than it is here. The role of the judge is different. Are they that much different to make those international guidelines unable to be applied here? I would not say that, but certainly the differences in the legal systems merit attention. For example, in issue 2, what we see here is that an expert witness was introduced in rebuttal. That means the defense did not know that expert was coming, did not know what the expert was going to be testifying about. That is not contemplated in the international guidance. If there's one thing that the international guidance emphasizes, it's transparency and giving people the opportunity to review and challenge the opinion and the data that the opinion is based on. So here, we had the expert come in rebuttal. Does that mean anything was wrong in this case? Well, it followed the applicable legal rules, but that means there's a tension between the legal rules and what the international guidance is saying should happen. How that tension gets resolved is a big question because right now it is unresolved. So that's one of the things that we point out in the report. Issue number 3, in the international guidance, in all the literature on this subject, the written report is the cornerstone of the work. And it's emphasized everywhere you look. So the idea is, again, that there should be a written report, and the report allows for one to review the conclusions, the basis for the conclusions. Now, in this case, the expert asked, Dr. Califoot asked the state if they wanted a report because he would have provided one. They said no. But keep in mind, the prosecutors are thinking about this from the perspective of the lens that they have, which is the lens into the legal rules and what the rules require and don't require, not the international scientific guidance on the very same subject, because they would have no way to know that unless the expert tells them that. So what you have, again, is this disconnect between what the lawyers are thinking and what the scientists are thinking. And we see that often in the work that we do. And part of the commission shining a light on these things is to try to bridge those gaps and provide education across. Number 4, and this is very basic threshold stuff that is in this book and everywhere, that experts need to understand what constitutes a well-formulated activity level proposition. In this case, the alternative proposition was not well formulated because it was circular and that it included results and transfer in the proposition, and that is not the way we would want to proceed. So we see that there's an education gap when it comes to formulating propositions. On this next issue, number 5, there's real questions about when these cases are suitable for an activity level evaluation and when they're not. So people need to understand when it's appropriate to proceed and when it's not. In the Netherlands, they do 5 of these cases a year, 5 activity level evaluations, because they're so time and resource intensive that that's all they can do. It's not something that can be done on the fly. So one of the things that they talk about, both in the literature and when we were talking to experts on this, is that it's just as important for people to understand how to determine suitability as it is to know, do I proceed with this or not, is a really important thing to understand, and that is taught through the education that's available. In this case, Dr. Califoot had his entire case file, which was an evidence reconciliation document and papers of interest that he forwarded to the state. So they did have that information, but they did not perceive it as a report. The documents, those documents that were sent, don't detail the connection between the data in the reference studies and the opinion offered, and they don't clearly justify the assignment's probability of transfer, especially given the alternative. So that is something that we would want to see fleshed out. One of the things that we do in the report is we attach 2 sample documents from Switzerland and another one that was published in an article that's been out for quite some time that show how extensive these reports are when they're done in other countries. And what we need to be able to do is understand that these reports will require some level of, whether it be NIST or the commission, someone needs to articulate what is enough for reporting, because otherwise we aren't going to understand the basis for the assignments of probability, among other things. So this is another one. In the literature, it is strongly advised to issue a numerical likelihood ratio, to issue that numerical likelihood ratio alongside a verbal qualifier, perhaps, but not alone. So because the opinion in this case did not have a number associated with it, and Dr. Califoot declined to issue a number, we asked, well, why? Because it seems like this is what most of the resources are advocating. A number needs to be calculated and reported. And he explained to us his view that there were 2 LRs for the case, and one was in the order of 10,000 and another was quite a bit higher. It may as well have been approaching infinity, and because those LRs were so high, he thought that the verbal descriptor of much more likely was a reasonable way to discuss the evidence. And there are problems with this explanation because what the literature does not say is that if you calculate an LR but you think the LR is too high, then you just go with the notional probability or the verbal equivalent. That is not what they recommend, and nowhere does it say that you disregard an LR because it's too high. If that's what the LR is, then it gets reported alongside the verbal qualifier. Query whether there is justification for LRs that are that high in this case, because in the literature it says for LRs to go that high, you would need detailed information on the history of the helmet, a considerable amount of data to help inform the assignment, justification for the method of adjusting probabilities with either expert knowledge or personal experience, and is that experience calibrated? So those things are all contained within the textbook. Activity level LRs tend to be many orders of magnitude lower than subsource LRs, in part due to the nature of the data, how much data are out there, and how it's organized. So those things all tend to push the LR down for activity. So what we say here is, on the state of the data generally, we need a systematic review of currently published literature on TPPR, background, and if the path forward in the US is going to be to implement evaluations given activity level propositions. To the extent US authorities have published on this, they say there's a growing body of knowledge on this, but significant gaps remain. And method development and validation in the US need attention. There are options. In the absence of published literature, there is not always sufficient data and published literature applicable to the facts of a given case. That is acknowledged in all the publications and the guidance on this. There are different ways one can approach this, but regardless of whether the expert uses published data, lab experiments, personal experience, or some combination of those things, transparency is critical. There's disagreement about whether it's appropriate to assign notional probabilities or whether you need to calculate a number, a numerical LR in all cases. It says in the guidance that the number is required, but debate on this subject is ongoing. Regarding education and training, it is not the same education and training that you get for DNA testing. Currently, the only source of university level credit coursework on this subject is in Lausanne, Switzerland at UNO. If you take a look at what they require in the Netherlands for someone to make it to the registry of experts on this subject, it is extensive. There's oral boards, they look at your casework. You don't get to testify on this until you've gone through quite a rigorous review so that a board of experts decides that you are qualified to do this work. We don't have that here in the US. We have a series of workshops at conferences or annual meetings that are insufficient preparation for analysts to go out and start testifying on this. So the position in this report is that SDOs, standard developing organizations like ASB and OSAP, need to address directly the level of education and training that would be needed for DNA analysts in the US. And that goes to another report that was recently issued by NIST about the need to educate analysts on these subjects. Issue number 10 involves the role of quality assurance and accreditation. In this textbook, the authors go to great lengths to describe that they think that accreditation will have a role here. So we need to be talking to the accrediting bodies about how they would, if they would, and when they would, add this type of evaluation to the scope of accreditation. And that raises questions about competency testing, proficiency testing, auditing, testimony monitoring. All of those things that come along with the quality system would need to be in place. And what they say in this book and other literature is that that is all critical to making sure that what is being offered on this subject is valid and that there is a way to correct through the quality system, just like we do for all other forensic science, if corrections need to be undertaken. So eventually it will play an important role. We don't know at what point. So a summary of the findings, the case would have been better served by a written report. Dr. Califa did cite 3 studies, but we don't actually know what constitutes enough data because that hasn't been established yet at any level, even in the international literature. So there are arguments about whether those 3 studies are enough to support the evaluation or not. Some may look at it and think it's reasonable, others may look at it and think these studies are too different from the case facts to even be used, or these studies use different kits, or they were done too long ago, or any number of things can be argued about the extent to which the literature could be relied on for this particular case. But that is something that I think would be debated in a very healthy way if a number of experts were to look at it. And then on the subject of assigning probabilities based on the literature, the evidence reconciliation document does not clearly justify the assignments of probability. And I think there's a real question about whether, given the absence of data close to the case facts, others may have viewed this as no LR should have been assigned. So there's real debate about whether this was the case to do this type of activity level assessment on or not. Regarding formulating balanced propositions, I think there's no doubt that an attempt was made to do that. But I think, unfortunately, the H2, the alternative proposition, was a series of explanations, case information, and DNA findings that is not supposed to be in the alternative proposition. So we note that in the report. And then we have these extensive recommendations. The first one is that there needs to be a foundational review subject to public comment of published literature by agencies with research expertise like NIST, and hopefully partnered with ISFG and MC, the international organizations. And that needs to include all of these subjects, and we go into that extensively in the report. We talk about the need for clear and specific standards in certain areas around guidance on method validation, education, training, and experience, quality control measures, components of an effective report, guidelines for testimony, and education and training for lawyers and judges, which is not a small thing. We go through in the report at some length how challenging the transition to probabilistic reporting has been. Likelihood ratios in the context of DNA testing is a hard concept for analysts to explain and for lawyers to understand. So now we're thinking about introducing a whole new level of that, and I think for some people there's concern that that may not be appropriate for all DNA analysts. In fact, in some of the other countries where this work is done, such as in Australia, they have activity teams, people who are trained in this. Not all DNA analysts would necessarily do this or even want to do this, frankly. And so there is some thought that if there was an activity team, that would take the pressure off DNA analysts, and they could say, you know what, you're going down the activity road, you need to talk to the activity team, and then they could have another expert within the lab who would be more suited and better trained to respond to those types of questions. We have an interim recommendation. Scientists, of course, can discuss background knowledge that they have. One would expect that they should be able to answer that. The challenge is when background turns into hypotheticals that are thinly veiled as background. So that's a hard thing, I think, for analysts to discern, but we do include in there some language that we think forensic science service providers in Texas should adopt. It is based in part on UNT's policy on the same issue, which is that when an analyst is asked a hypothetical question that requires consideration of TPPR principles, the witness should communicate that the comparison results don't answer the question of how or when, and they should reiterate that while they may be able to provide limited or basic information, answering those questions is beyond their expertise and would require a separate evaluation. I would commend again to you the reading of Sam Perkins' transcript to see how she tried to do that in this case. And I'm sure when she looks at it, she probably thinks of all the things she could have done better, because that's just the nature of forensic scientists. They're very self-critical, but I think it is a good jumping off point for discussion. And then we reiterate that, and we believe that regardless of whether you're in an accredited lab or not, if you are doing forensic science work and testimony in the state of Texas, you should follow the principles of the Texas Code of Professional Responsibility to the extent you can, to the extent they apply. And we feel very strongly that one needs to obtain education and training at the level discussed in this book and in other places before serving as an expert. It's not something that you can do through a workshop and then start testifying. We really want to emphasize that. And obviously we need to be issuing written reports containing balanced, transparent, and robust evaluations that are clear on the assumptions and models used, provide traceability of analysis, by articulating the source of knowledge for the assigned probabilities, including their limitations, communicating to the lawyers what is in the international guidance when it feels like what they're telling you to do conflicts with it. I think there is a responsibility to step up and let the lawyers know, you know, I'm sure you're thinking of this through the lens of the legal rules, but I just did want to let you know that either best practices or the guidance on this really say I should issue a report. So when you issue when you do DNA testing and issue your results, nobody asks the prosecutor, do you want this report or not? They get the report as a matter of course because it's a requirement of the FBI's QAS and accreditation. The rest of the world doesn't treat this type of analysis any differently. They issue reports for this analysis, just like they do for subsource evaluation. And then proficiency testing, technical review, bias mitigation, all of those things to the extent possible should be integrated, and declining to offer ad hoc evaluations on the stand is important. We did want to thank everyone, of course, and for starters, the people who are involved in this. I know this is one of the hardest areas of forensic science right now, period. And so I wanted to thank the people who are directly involved, Dr. Calfoot, Ms. Roy, Mr. Quartara, Ms. Perkins, and in addition, to thank the people who reviewed this report, some of them multiple times, to make sure that what we have in there is on solid footing. And you can see all the names of all these folks, including the foremost experts in the field, as well as lawyers at the FBI, practicing prosecutors and defense lawyers. NIST looked at it quite thoroughly, DPS. So we are grateful to everyone who looked at these many drafts that we had, and also to Dr. Calfoot and Ms. Roy and Mr. Quartara and Ms. Perkins. I did want to say that Erica, Ms. Zemak, and Dr. Coble and Mr. Daniel were all members of the panel, and if you all want to add anything, if I left anything off, it's a hard and complex area, so I'm happy to answer questions.
Very well done. Very well.
I'm going to take my book now.
Thank you. Dr. Calfoot, would you like to speak?
Yes, thank you.
As a public speaker, you got 5 minutes. I'll let you know when you got a minute left.
So I got 5 minutes to rebut 6 months worth of work in a 66-page report. Seems reasonable, doesn't it?
Well, that's what it is.
Okay. I want to remind everybody here, it's been said, I don't have to be here. I'm not subject to this jurisdiction. However, I like to be open-minded. I like to be a scientist that's always looking for a place to learn, always looking for a place to advance, and always looking for a way to move forward, okay? Now, I also think in my day job, unconnected to this, I'm a professor. And I tell my students you can learn from my 25 years of mistakes. Problem is there's a lot of new ones that you have yet to discover. So I'm happy if other people can learn. But there are some things said. Number one, the complaint was 5 bullet points. They're easily and straightforward dealt with. Bang. I did the research. I started with 30 papers, got it down to 4. All of my values that all of my probability assignments and assessments were based on literature. I provided that literature to the state. I was ready to provide it to the defense. I'm told that the defense, let me take just a second, take a breath. I'm told that the defense in the state of Texas can ask before the rebuttal starts to meet with me. Now, I might have upset the prosecution, but I would have done so. As far as this thing about the report, the information changed. I didn't prepare a report, that's true. But the math, the equations, everything was in my document, if you really know how to read it. Once I was told no one was gonna see this but me, they became my own personal notes, and the math is there. The equations are there. It's not, I've talked to some experts on that list who recognize it and have confirmed it, okay? But they were for me. The part to make public, I was told, don't waste your time. One reason being, we don't know if we're gonna use you, and we don't even know what we're gonna ask you, because we don't know what the defense is going to say. This concept of a poorly worded secondary, alternative proposition, it was a hard one to word. It was. It required 4 specific activities to be discussed. I could use more practice in that. That was complicated. But I wasn't asked to consider some other thing. I was asked to consider a chain of events that were 4 specific activities. It's not up to me to decide what set of propositions to address. They were given to me directly and overtly. The recommendation that y'all are gonna decide on today is a clear message to practitioners. When the court wants to know about activities, don't do it. It's called a refusal response, okay? Some of the examples taken from the report, which are taken from the non-peer reviewed, not even put out for public comment, NIST foundational reviewer on human factors are, it is not my role. It is not my role to speculate about or determine what happened. DNA analysis does not allow scientists to directly answer how the DNA was deposited. This is different from all of those other guidance documents that have been referred to today. They give overt guidance on what should or could be done. No one says the response should be, I'm sorry, all I can tell you about is whose DNA might be there. So technically you're outside of the state of Texas that if a lab adopts this response, they might as well just stop doing property crimes cases, firearms cases, and most 3- and 4-person mixtures aren't worth reporting because those are the questions that the court are interested in for those kinds of samples and items of evidence. That's just the facts. It's common throughout the US that those are the questions asked in these, for lack of a better term, touch DNA cases. I heard from a technical leader in the state of Texas that had one of their new analysts that they went to go review was given papers by the defense, and the judge made them take 20 minutes to read it and came back and testified by reading highlighted cherry-picked sentences that basically say, yeah, indirect transfer is possible. So I don't know how this is going to be implementable into the state of Texas, because if the guidance is for the lab expert to say, I can't address this, I can't talk about this, I can't say anything, the defense can turn around and literally say anything's possible. And they can use the lab expert to do it by handing them papers with sentences highlighted. This violates every bit of guidance by the NC, by the ISFG, the UK Forensic Science Regulator. This concept that it has to be a number, UK Forensic Science Regulator says that if there are no direct studies on point, then only a verbal LR is suitable. Now, the actual propositions I was dealing with when I did the written work was Armstrong and motorcycle, motorcycle Wilson, Wilson and bicycle. Case information that no one knows but me and the prosecutors is that they cleared the information with Mr. Strickland, who owns the motorcycle, that when he rode the motorcycle the morning of the event, a month after Armstrong last rode it, they made sure they asked him about how he sits, where he sits. And they confirmed to me that he slides back and forth on the seat of the motorcycle, essentially that he would have touched all the areas that the defendant touched when she rode it a month ago. That's something that I considered. At the end of this chain involved that DNA being on the defendant, on the victim, on her hands, and then doing something with her bicycle. The prosecutors told me that she was on her cell phone from the moment the door code was punched in to let her into that apartment, that there's no case information whatsoever that she touched that bike, moved that bike, rode that bike, did anything with that bike. You can get some pretty big LRs when that's the situation, when the chain of events can't happen. So yes, I chose to give a verbal LR, which is in line with both NSP under certain conditions and required by the UK Forensic Science Regulator under specific conditions. There's a way forward. There's a way forward. I would invite the Commission to contact the Center for Forensic Science in Toronto, Canada. They've got a team of people who are authorized and expected to go to court and give a balanced reading of papers. They've got papers curated, they've got people trained on it, they've got the data mined. And they don't go to court and agree that, yeah, anything's possible, nor do they go to court and say we can't say anything. They're working towards something more formal. They admit this is a little bit of an uncomfortable gray zone, but there are ways forward. I really struggle to see, I'm glad I'm not a crime lab practitioner in the state of Texas. If I'm stuck between telling the prosecutor, all I can tell you is who may have put it there. I can't answer anything about how. That prosecutor is getting frustrated because on cross, the defense gets the person to testify by reading cherry-picked sentences. And this poor lab person sitting there saying, I'm not supposed to say anything, but the judge is making me read this. I think that this is not a hypothetical. I've been told about it in Texas. I've also talked to a more senior examiner, well, the tech leader was standing right there, that the response is, if I can't use my hard-earned expertise, I might as well just retire. So there may be some unintended consequences if this report is accepted with these specific recommendations that you all need to stop and think about. But this is your purview. This is why you're here. I have no influence on you. You can do what you all wish. I hope that you at least think about some of these potential unintended consequences. I'm actually aware of a university nearby that is fully funded by the Texas State Legislature to provide a PhD degree in forensic science. I'm aware that that university has a faculty member who has a PhD from the University of Lausanne, who are generally considered some of the experts in this field. This faculty member teaches things like likelihood ratios and activity and Bayes-Nets in his coursework. This concept that we can't understand in LR, that we can't make it understandable, this is what we teach. Absolutely we can. We might need to spend some time teaching the experts in Texas how to do a better job, but that's an achievable goal. This university also has a faculty member who basically introduced hundreds of US practitioners on the very evaluated tool, the probabilistic genotyping software, that is used in Texas and throughout the country. I would kind of hope that we don't have to go to Switzerland, that there are some resources closer to home that could help the commission find a way to move forward. Clearly, the court is interested in these questions. They're not gonna go away based on what you all decide. The questions are still gonna come. And saying, I can't answer that, or anything's possible, requires zero expertise. That's not being an expert anymore. So, let me apologize for 5 minutes throwing me and ramping up my heart rate a little bit.
It was actually 10, but.
Okay, well, I got my heart rate going a little bit. I didn't mean to show up here and blast people with bow barrels, but holy cow, 5 minutes? My prepared remarks are a little more calm, a little more laid out, but I think I've said the gist of what I wanted to say. Look, I'm on record of applauding this commission taking this on. I kind of wish that the 5 bullet points would have been dealt with bing bang boom, because they're straightforward. I mean, I did the work. I used the literature. I'm unaware that a witness is supposed to self-supply reports when the court says it's not required. That's a new one on me. And yeah, the proposition, that was tough. That's an area where I have room for improvement there, clearly, especially now that we've had dozens of people picking through this for months. I think anytime we have that happen, we can find areas for improvement. It is true, forensic scientists are hard themselves. You know, I wish I would have figured out a way to communicate that complex 4-step process better than what I did. But I'm just gonna close by repeating, I think you guys are in danger of putting Texas forensic scientists into a really, really difficult position. Allowing for general background information to be given, but nothing case specific, when that's not clearly defined, I think that's gonna be a real problem. That's my little 2 cents here.
Thank you, Dr. Calvin. I think one of the issues that's a challenge in this is that we can deal with the forensic science aspect, but we have no say-so or control over lawyers. And they both have their different goals, and we don't regulate them. So you're mixing 2 different issues into an environment that, to be able to prosecute a case, they want to withhold information in something like a rebuttal, and the defense doesn't want to be forthcoming because they have their side to represent. So it is a complex issue. And I thank thank Lynn for the presentation. Dr. Calvin, we appreciate your input as well. So now we have to address whether there's going to be motion to accept the report. I know we have recusal. We will have to recuse Dr. Kerrigan, Dr. Buzzini, and Mr. Parsons.
Can I, just one thing that I don't want people to misunderstand what the recommendations are. So we're not saying that people can't. We're saying people need proper education and training before they do, which is a path that has not yet been laid, and we need to really focus on that. Just want to be clear, unless Dr. Coble or Ms. Zemek. The idea is that we need to be very thoughtful in proceeding, that's all.
Very challenging issue. So with that in mind, is there a motion to accept the report?
So moved on it.
There's a motion on the table to accept the report. Is there a second?
Second.
All right, there's a second. All right, all those in favor say aye.
Aye.
All those opposed? 3 recusals. Motion carries. All right. Agenda item number 9 is the upcoming forensic development training and education projects.
So the main one that we have coming up, and I think you have the outline of it in your materials, is that Dr. Cole and I have laid out a series of combined virtual and in-person trainings on a wide variety of subjects. The first one will be a month from now on the wide HPD interval issue and star mix that we've seen in quite a few different labs. We also discuss other issues that we wanted to circle back on involving activity, involving that discussion that we had when we did the James Smiley report on exclusionary decision-making. There are a number of things in there that we're excited about. We could probably plan 6 years worth of trainings, but we're gonna try to start with 4, 2 of which will be in person and 2 of which online. So we'll be reaching out to all the labs that have DNA sections to talk about how we will be approaching that, but it'll be similar to what we have been doing. It'll probably be either in Waco at the Rangers facility there, or at UNT in Fort Worth. Maybe at DPS in Austin if we want to do it here. So we're excited about that. That's the main training item coming up that we'll be focused on. And other than that, I would say stay tuned on training goals.
Number 10, update from Texas Associated of Crime Lab Directors.
Dr. Kadavy has an update because Dr. Stout was unable to be here, sends his regrets.
Especially since he's traveling, I'm sure. So, thanks for having me, Dana. And the TACLID met on the 18th, so last week. We had a really good turnout. We met virtually this time just because we couldn't align that meeting, this meeting, which we normally do. And the good news is we welcomed a lot of new members at that meeting, voting members and regular members. So we're almost at 75 strong, which is awesome. We got an update from our treasurer about the accounting, and our nominal dues are doing a good job of keeping us, up to date with holding up our website and those costs. That's nice. We had Kevin Callahan, which is the Records Portal Program Supervisor from Texas CBS, come in and give us a great update on the state of the Texas CLR Connect portal, which is amazing, and we really love the newsletter that's being put out and shared. If you haven't seen it, it's got great information on what it is about, what they're trying to do, tentative timelines, and point of contact. So if you have questions, you know who to reach out to, so thank you for that. Lynn, thank you for your updates from the commission. I think you hit these, but of note for us is that all your portal pages, all 6, are up and live, which is amazing. I was most interested, and I think we all were excited about the QI page. And thank you for putting the disclaimer on there that it just went live in July 2024. So we all don't need to freak out. It says very clearly on there, hey, don't go looking for all the information in there quite yet. Labs have to have a chance to put our information in there. So I thought that was very nice and helpful. And talked about maybe having some entry options for folks that are OSAC compliant, but maybe not accredited. So I think that's a good opportunity. We had a really good presentation and discussion led by our legal gurus, Mance and Boswell, about the Knoll, Heath, and Smith versus Arizona. And what does that mean for us as forensic service practitioners with regard to discovery, with regard to confrontation rule? What does that look like? And gave us just some really nice insights about what that might mean, and cautioned us in that it is highly dependent on an individual jurisdiction, and there's a lot to be learned. So it's really just encouraging us to talk more about it, think about how that might impact our resources and how we would prepare for that. So I thought that was very helpful information that they shared with us. And Peter covered, upcoming potential legislative activity. I know our intergovernmental relation offices for all of us are asking for input on agenda items. And so we've been collaborating amongst the group members so that we're sending in sort of common themes. And some of those really that we've been talking about surround workforce development for forensic scientists, like a good high education, maybe some certifications and extra training, so that burden is not landing solely on service providers. And then also some ideas about streamlining and helping us make the whole idea of evidence disposition a little less burdensome and kind of propel us forward with, how do we get those authorizations? Peter did a great job of sending the TACLID a couple of memos on those two topics, mostly surrounding toxicology blood tubes, but that could extend to a lot of different evidence dispositions and also on workforce development. So we're looking at that, providing any feedback, and also sharing that with our individual agency representatives. So hopefully we'll be loud and represented at the legislation. Anything else I missed from you? I think that's it.
Thank you.
Thank you.
Thank you.
All right, item number 11 is discuss membership in the National Association of Forensic Science Boards.
So some of you know that there is an organization that's been formed called the National Association of Forensic Science Boards, and the inaugural meeting was held here in Texas because Texas, I think, is widely regarded as a leader in this area. Other states have different variations on the theme of what we have here. Some of them have commissions, some have boards, they have different oversight authority depending on the state, and this organization is designed to coordinate among our counterparts in other states, whichever states they may be. Because the vast majority of crimes prosecuted at the state level, with the exception of the work that NIST does, most efforts at some level of oversight or regulation at the federal level have failed. Really, where the success is at the state level, to the extent it's been experienced, we've seen. So we have another annual meeting coming up in November in Albany, and we're really encouraging people to become members of the NAFSB so that it can grow its base and serve as a resource to commissions and boards that are just starting up. I know that there's a delegation coming from Oregon in the fall that want to meet with legislators here because they want to start their own commission, and they heard that Texas is the best, so they're coming here to learn from us, and they're going to talk with some of the legislators who were involved in creating the commission originally, along with, I think, Judge Hervey will be there, Texas DPS will be there, we'll be inviting the governor's office to join, to have a conversation about really, how the commission started, what has worked, what hasn't, the role of the different policymakers, legislative perspective, governor's perspective, the lab's perspective. So we're looking forward to that, and I think it's just, that's sort of what's happening around the country right now. And since we've been around, New York just completely overhauled its statute, and I opened up the email I got, and I opened it up, and I'm like, they literally took our statute, crossed theirs out, and plopped it into this bill, and I was like, and part of the rulemaking we have. So it's been interesting to watch that, and I try to have the requisite humility that we should all have. No commission or board is perfect. We've had our share of challenges certainly over the years, but it's been really interesting to watch how many states are reaching out to say, we want to do something like what you have here, like Colorado. They just had that big thing go down in their state Bureau of Investigation, so they're calling, they usually call Peter Stout first and then eventually make their way to us. So for those of you who are interested in participating in that, we'd love to have you, and we'll send email or information about the conference that's happening in November. I know they'll be inviting Dr. Kerrigan to speak at that because she's been around since the very beginning, and they wanted to get the perspective of universities and what their role can be with the commission, and the work of forensic oversight. And Brady will be speaking on a panel, so we'll send that information around and resend it to the TAC. Actually, Dana, I'm not sure if you guys got that or not, but we'll send it back out again. So it's exciting that we're not so lonely anymore. There are a lot of states doing the same thing.
They said Texas is the best.
Clearly, yes.
For science or football?
We didn't talk about football.
That's not on the agenda.
Not on the agenda, it's against, yes, not. We can put it on next time.
We need to. All right, so the next item is to consider proposed agenda items from next quarterly meeting. Are there any matters the commissioner wants to place on the commission meeting agenda? Not hearing any. Then the next is we need to schedule the next meetings, which are tentatively listed as October 25th, 2024, January 31st, 2025, and April 11th, 2025. Is there a motion to direct the staff to schedule these meetings?
So moved.
There's a motion, is there a second?
I'll second.
A second. All those in favor say aye.
Aye.
Opposed? Okay. Is there any remaining public comment? Hearing none, do I have a motion to adjourn the meeting?
So moved.
Second?
I'll second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you.